Welcome to a deep dive into, well, one of the most fundamental yet easily missed traps in all of contract law, the constructive condition of payment. Specifically, we're asking the question, if you hire someone to do a big job and your contract is completely silent on when they get paid, when is that payment actually due?
The silence it's exactly why so many contract disputes end up in court. The parties, they assume a common understanding, but the law imposes a really stringent default rule. Our sources today center on the classic, game-changing decision of Stewart v. Newbury, which provides a surgical answer to this problem.
The classic scenario, right? A contractor bills early, the owner refuses to pay, and then the contractor just walks off the job claiming breach.
Precisely.
That is a situation almost every business owner or, contractor faces at some point. Our mission today is rigorous. We're going to unpack the three-part analytical test the courts use to determine payment timing. We want to give you a diagnostic tool to really understand the difference between an entire contract and a contract that's legally divisible. Okay, let's unpack this.
To resolve the conflict in Stewart v. Newbury, we really have to first establish the common law default rule, the one for constructive conditions regarding the duty to pay. We're focusing on the doctrine of the entire contract, which defines not just the agreement, but the sequence of performance that the law requires.
So if two parties agree to a major project, let's say building a concrete mill, and they never put anything in writing about progress payments, what rule does the court impose? When does that legal condition of payment actually kick in?
When the parties are silent, the law constructs a condition precedent. The general rule, we call it the entire contract default, is that unless the agreement specifies otherwise, the work must be substantially completed before payment can legally be demanded.
Wow. So if I'm building a house, I don't get paid until the house is pretty much done unless I explicitly write progress payments into the agreement.
That's it.
That seems to shift the financial risk entirely onto the contractor?
It does, precisely. And this entire analysis, which we'll use to dissect the case, hinges on answering three sequential questions. These become the elements of the legal test. First, is this an entire contract? Meaning, is it a single unified performance, or is it broken into agreed-upon exchange pairs, which would make it divisible? Second, assuming it's entire, is there an absence of payment terms? Did the parties just fail to agree on terms, either explicitly or through some kind of recognized trade custom? And third, if both of those are true, the payment trigger is not flexibility or fairness, but substantial performance.
Okay, that distinction between entire and divisible seems absolutely critical here. Can you quickly clarify what a truly divisible contract looks like, the kind that would let you bypass this really tough default rule?
Certainly. A divisible contract needs clearly defined corresponding performance and payment units. For example, say you hire an artist to paint 3 separate murals.
Okay.
And the contract specifies that mural 1 is due May 1st for $5,000, mural 2 on June 1st for another $5,000, and so on. Those are agreed upon exchange pairs.
So the duty to pay for the first one is triggered when that one is done.
Exactly. The duty to pay for mural 1 is triggered when mural 1 is completed, regardless of whether mural 2 is ever even started. That's fundamentally different from a single contract for one completed mill building.
That makes the stakes incredibly high for getting the language right from the start. Let's analyze Stewart v. Newbury to see how this played out. First, what are the key facts that set this whole dispute in motion?
Okay, so the contractor, Alexander Stewart and Newbury Manufacturing, agreed via exchanged letters, this was back in July 1911, for Stewart to build a concrete mill building. The contract specified fixed unit prices, $2.05 per cubic yard for labor and forms. But the crucial omission, the thing that caused all the trouble, was that the letters said absolutely nothing about when payment was due.
Right. And I understand Stewart completed work up to the first floor, but what was the pivotal factual conflict, the thing they argued about regarding the payment terms?
Well, Stewart claimed that after the written agreement, he had a phone call with Newbury. He said they agreed payment would be made in the usual manner.
The usual manner. What did he mean by that?
Stewart interpreted that to mean 85% monthly payments with a 15% retainage. But Newbury denied this call ever happened. They insisted they never agreed to any monthly payment schedule. So Stewart works for 2 months, sends a bill for $896.35. Newbury refuses to pay, and Stewart promptly abandons the job and sues.
And what was the core legal issue that the Court of Appeals ultimately had to resolve?
The precise legal question was whether the trial court made a mistake. Did it err in telling the jury that if no express agreement on payment timing existed, the contractor could still demand payment at merely reasonable times as the work progressed.
So the whole verdict depended on that jury instruction.
The validity of the entire verdict rested on defining the correct constructive condition.
Yes. What rule of law did the Court of Appeals apply? Please state the full black-letter rule that governs this kind of contract performance.
The court applied the fundamental rule for contracts for services. When a contract is made to perform a unified work, and no agreement is made as to payment terms, the work must be substantially performed before payment can be demanded. This just confirms the rule we discussed, and the court analyzed it using those three elements: contract type, absence of terms, and substantial performance as the trigger.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element determining the contract type? Was it entire or divisible?
The court quickly established that this was an entire contract. They looked at the agreement's subject matter: a single, unified effort to produce one completed structure.
Even though the price was per cubic yard?
Yes, even though the pricing was based on units, the law presumes that if the total result is a single objective, the performances are exchanged at the end. The owner's primary goal was a completed mill, not, paying for every cubic yard as it was poured. So that element was met. The contract was entire.
Understood. Now, what about the second element, the absence of terms? How did the court treat Stewart's claim that this oral agreement, or custom, for monthly payments should have controlled?
This is where the risk allocation becomes really clear. The court said that if the jury believes Stewart's claim that Newbury agreed to monthly payments, then that express agreement would control, and Newbury would have been in breach for not paying. However, because Newbury denied the oral agreement, and Stewart couldn't definitively prove a binding mutually understood custom that was incorporated into the contract, the court had to proceed as if the contract was legally silent.
And since the written part was silent?
Right. Since the written letters were silent, the default rule was unavoidable if the jury rejected those oral terms.
And here's where the fatal error occurred. Assuming the contract was silent, the trial judge told the jury the contractor was entitled to payment at reasonable times. How did the Court of Appeals analyze this third element and determine that instruction was just fundamentally wrong?
The instruction was a fatal error because it completely ignored the settled policy of the entire contract rule. The court stressed that the default condition is not reasonableness. The default condition is substantial performance.
And he hadn't substantially performed.
Not even close. Stewart had only progressed to the first floor, which is far from substantial performance on a multi-story building. By instructing on reasonable times, the lower court basically let the contractor off the hook. It relieved him of the obligation to finish the work before seeking payment.
So it was like rewriting the contract.
It was essentially rewriting the contract's fundamental sequence of duties and improperly shifting that financial risk back to the owner mid-job.
And after analyzing all the elements, confirming it was an entire contract, likely silent, and subject to that completion rule, what was the court's final conclusion?
The judgment for Stewart was reversed and a new trial was ordered. The holding was crystal clear. Because the contract was entire and silent on payment terms, Newbury Manufacturing was not obligated to make a partial payment prior to substantial performance. Stewart's decision to abandon the work after sending a premature bill constituted a voluntary breach on his part, not an excusable non-performance because Newbury didn't pay.
That analysis really shows the extraordinary power of that default rule. If you fail to write in installment payments, you are essentially providing the owner with interest-free financing until the job is almost done. Let's cement this with a hypothetical. Imagine a homeowner hires a contractor for $10,000 to remove a huge, dilapidated ancient septic tank buried deep underground, and the contract is silent.
Okay. So if the contractor expends huge effort, digs this massive, disgusting hole, exposes the concrete tank, and then sends a bill for, say, $7,500 claiming 3/4 completion,
The homeowner can just say no.
the homeowner can absolutely and lawfully refuse to pay.
And why is that? I mean, the contractor did the hardest, most visible part of the job.
Because the goal of the entire contract was removal. That means the tank is gone, and likely the hole is safely filled and graded. The owner bargained for a specific result, a usable yard, not a giant hole with an exposed tank in it.
Wow.
Payment is constructively conditioned on receiving that benefit. By refusing to pay the premature bill, the homeowner is not breaching, they're simply insisting on the performance that triggers their reciprocal duty.
So if the contractor walks off at that point?
They are the one in breach, just like Stewart. The policy ensures the owner's payment leverage remains intact until they get the benefit they actually paid for.
That really grounds the concept. It links the performance directly to the ultimate bargain-for benefit. For anyone listening who's trying to apply this knowledge, can you synthesize the rules we just discussed into an actionable, step-by-step diagnostic checklist?
Of course. Understanding the sequence of analysis is key to solving any problem involving these constructive conditions for payment. Here is the practical diagnostic framework for payment timing in contracts for work.
Step 1 has to be about what the parties actually agreed upon.
Step 1. Express terms. Yes. Always look first for the parties' explicit agreement. Does the contract state specific payment schedules, milestones, or percentages? If it does, those express terms always supersede the default rule. They govern the timing. Period.
And if the contract is completely silent on timing, what's the next layer of inquiry?
Step 2. Custom, course of dealing, or usage of trade. If the contract is silent, you next have to assess whether there's a mutually accepted trade, custom-like that monthly 85% rule Stewart failed to prove, or maybe a prior course of dealing between these specific parties that dictates timing. If that custom or course of dealing is binding, then it controls.
Okay, and if both of those fail, now we enter the territory of the entire contract default.
Correct. Step 3. Entire versus divisible. If the contract is silent, it is presumed entire. So you must ask, did the parties clearly structure the agreement into agreed-upon exchange pairs where a portion of performance is explicitly linked to a portion of payment? If there are no such pairs, the contract is entire, and that big default rule applies.
And the final defining step that we get from Stewart v. Newbury.
Step 4. The default trigger. If the contract is entire and silent, payment is triggered only upon the satisfaction of the constructive condition precedent, substantial performance of the entire work. Any demand for payment made before substantial performance is premature.
And refusing that payment isn't a breach.
Refusing that premature payment is not a breach by the owner, but abandoning the work based on that refusal is a breach by the performing party.
This rigorous analysis really shows that if you are a party performing a service under a silent contract, the law requires you to carry the financial burden of performance until you deliver the goods. The silence of the contract speaks volumes in favor of the party receiving the completed benefit.
It does, and the policy rationale behind it is powerful. If the owner pays early, they risk having to hire a new contractor to finish the work using money they've already paid out. The law protects the owner's retention of leverage.
So this case focuses entirely on the contractor failing to finish after the non-payment. But here's a final thought. If the contract was entirely silent and Newbury had just paid Stewart that premature bill of $896 without any protest or negotiation, would that one single voluntary payment potentially change the legal nature of the contract from entire to divisible, thereby setting a precedent for future monthly payments? That single choice could fundamentally redefine the risk for the rest of the job. That's for you to explore.